Florida's social media law meant to prevent deplatforming and censoring users is now headed to trial. The case previously reached the U.S. Supreme Court, but now it is back in Tallahassee. Matt Hoffman has an update.
A federal judge right here in Tallahassee is set to decide whether or not Florida can implement a social media law meant to prevent deplatforming and censorship. But a trade association says the law still violates the First Amendment, and they're confident they will prevail. According to a Florida Senate analysis of the law, a social media platform would be fined $100,000 for deplatforming any statewide political candidate. They'd also have to publish their standards for shadow banning and give users certain opt-outs. But this law has been blocked since 2021, when a federal judge found it violated the First Amendment. After the U.S. Supreme Court ordered the trial judge to take another look, the judge ruled this month that the case is going to trial, according to an industry trade association. However, Florida cannot implement the law while they wait for that trial.
Rights to make editorial choices about what they think their consumers, their public, their community want to see.
Previously, state leaders said in court filings that social media companies had been moderating their content arbitrarily and in bad faith, and using their power to silence those they don't like, including by removing a COVID-19 panel Governor DeSantis convened.
The overarching analysis is that the state cannot second-guess editorial decisions, and choices about what's appropriate for an online community is not all that different from a newspaper editor's choices about what its readers want to read.
But in a ruling earlier this month, the judge already ruled that the law was in fact meant to, quote, eliminate liberal bias, and so it was already unconstitutional in some respects. Still, the law is headed for trial and we'll be with you every step of the way. For now in Tallahassee, I'm Matt Hoffman.